the nightmare is she'll forget to push the record button, not have the boom mic on, like that. But I've been very good. I've had very few problems. I'm into my 8th year now, so it's been a good run.
Good.
Okay, we're here today with Lee Plakas and his associate Edmund Mack, and the topic is Tom Bernabei, Stark County Commissioner, May 4th, 2015, files as an independent candidate for mayor of Canton. On May 29th, Lee Plakas files a protest on behalf of the Stark County Democratic Party, the Ohio Democratic Party, and 7 council persons out of 11 Democrats, an impressive number, Lee and Edmund. I figure that's about 63% or so. So to get to the filing on May 29th, there had to be action by the Stark County Democratic Party Executive Committee to authorize the litigation and to hire Lee Plakas and his law firm. Can you tell us a little bit about that particular part of the proceedings, Lee?
Well, subject to it as an attorney, of course, Martin, you know that any communications between an attorney and their client are confidential, and ethically I'm prohibited from disclosing those things. So since the Stark County Democratic Party Executive Committee determined to retain us so we could file the protest, I can't go into the specifics, but I can tell you that Edmund and I did appear at a meeting at the Stark County Democratic Party headquarters, and issues were discussed, and as a result of that, we were retained and authorized to file the protest.
Now, do you include in your understanding of your clients not only the Stark County Democratic Party and the Ohio Democratic Party, but the individual protesters also?
Yes, we do.
Okay. And of course, one of those protesters was Edmund Mack, who's a Ward 8 council person. Do you see any kind of conflict of interest in him participating as legal counsel and as being a protester?
Actually, I do not, and I think both pragmatically and under the ethical rules, there's no problem with that.
Okay. Now, your own connection with the Democratic Party. One of my blogs I picked up in 2014 under the name Lee Plakas, Campaign Finance Contributions, $3,500 to the campaign of William J. Healy II, who is not a party to this particular litigation. But he stands to benefit if you're successful in convincing the Stark County Board of Elections and or the courts beyond that Mr. Bernabei is not qualified to be on the ballot in November. So can you share with us your political connection with the Stark County Democrats and with Mayor Healy himself?
Sure. I'm happy to do that, but if I may first, Martin, if I may respond to the portion of your question where you indicated that Mayor Healy stands to benefit. The reason we're involved in this matter from a philosophical standpoint is I believe that the rule of law stands to benefit if we're successful. And that's the most important thing to me. The rule of law and the fact and the principle that no man is above the law. In fact, I like one of Teddy Roosevelt's quotes where he says that no man is above the law and no man is below the law. And what I believe that Teddy Roosevelt meant by that is clearly no man, regardless of how high his position is and how important and powerful he is, should not be permitted to skew or pervert the laws for his own personal gain. Teddy Roosevelt went on to say that no man is below the law, and I thought that was interesting. And I thought that's a good insight on what Teddy Roosevelt knows about the human condition. And I think what he means by that is that you're not allowed to do things under the cover of darkness. You're not allowed to go below the law. And either, if Teddy Roosevelt was here, he'd probably say, you're not permitted to slither around below the law and to avoid the law. And he went on to say in that quote that we should not ask men to abide by the law. They should know that. And I think good government is recognizing the rule of law. Good government is understanding that no man is above the law, and in Teddy Roosevelt's words, no man is below the law. So that's what I think this is about. The rule of law is something that if we ignore it or allow personalities to supersede or circumvent the rule of law, then all of us suffer. Today, one group may suffer or one individual, but ultimately everyone suffers. The community suffers, our society suffers. You're a good historian, you're also with your political science background. You're aware of societies, countries, groups that once they forget that, and once they say, well, we can justify ignoring the rule of law because of the fact that we really like this personality, whoever it may be, I don't have to remind you of the countries and the wars that have started because people were willing to ignore the rule of law and say, it's okay because this person or this personality is so important or so good or so dynamic or that we don't have to follow the law. So, if in fact, back to your question, Mayor Healy benefits from our efforts to enforce the rule of law and to enforce the principle that no man is above the law and that good government demands that our elected officials and our citizens recognize the importance of the rule of law, then I think all of us benefit, not just Mayor Healy.
Well, have you been in contact with Mayor Healy at all with regard to this litigation?
We have, as due diligence would require, have talked to virtually everybody that has any information on this issue. And that would, of course, include politicians. It would, of course, include citizens. It would include everyone. Part of what we do, of course, as an attorney, as you recognize, is who we specifically speak to is work product. And that's a work product privilege that, of course, we can't divulge to the other side of what we're doing. But you can anticipate that a good and prudent and energetic attorney or law firm would leave no stone unturned.
Okay. Now, I have had a number of conversations with other attorneys,
Mm-hmm.
and they're all want to weigh in on your charted position in your pleading, the brief that you filed on the 29th. And one of the first summations was, it's a great work product, it's a terrific pleading, but it's overkill. Do you have a reaction to that kind of observation?
Well, if the worst thing that people can say about our law firm or me as an attorney is that we are too energetic and do too much work and turn over stones that don't need to be turned over, then I will take that. And whether it's a compliment or a slight or a criticism, I don't think anything is overkill. You know, I've been practicing, Martin, we're contemporaries. You've been practicing since 74, myself since 76, so that would be 39 years for me. I've tried hundreds of jury cases. We've talked about the longest civil jury case in Starr County's history that I tried. And I have found that in law, there's, in terms of preparation and searching for evidence, there's really no such thing as overkill. Now, in front of a jury, if an attorney drones on and on and on and on, of course, then at some point the jury starts nodding off, and that is overkill. But I think what you have to do is amass all of the material information and lay it out there, and then that you make sure that you don't overlook anything. And in this case, it's interesting because there's, as you know, at least two primary issues, and there's numerous facts as to each issue. So we wanted to put all of that information in front of the Board of Elections, and we wanted them to have the opportunity to begin to digest that. I sensed that as they waded through the literally hundreds of pages, that perhaps they would have wished that we could have done a more typical protest of 20 or 30 pages. The problem is that the evidence that was created by the trail of the putative candidate created a lot of evidentiary information that we thought we needed to include.
Well, for instance, on your work about how long Tom Bernabei's been a Democrat, you put a very nice chart in your pleading that takes him back to 1976, which is same era that you and I got started.
That's correct.
And as a Massillon Law Department connected person under Thomas Ferraro, who happens to be the brother of Starr County prosecutor John Ferraro.
Yes.
So that's going back quite a few years as a Democrat connected person.
Sure, and the reason I raise that, and oftentimes you can get to the bottom of even the most complex cases by looking at the words and the conduct of the person that may be the subject of a trial. In this case, the words of the potential candidate were that he is a dyed-in-the-wool Democrat. And I've always thought that I knew what that meant, but actually I went back to every dictionary that I could find to make sure that I knew what it meant. I actually brought some of those with me today to make sure that I don't misquote any of the dictionaries, but basically a sampling will reveal that the dictionary definition of a dyed-in-the-wool anything, dyed-in-the-wool means having strong beliefs, opinions, etc., that you are not willing to change. Bred in the bone is a synonymous phrase. Dyed in the wool, it's of someone permanent or extreme. If you describe someone as dyed in the wool, you mean they have very strong opinions and will not change. And dyed in the wool means that the dye isn't just a surface dye. It's not a spray paint. It's you imbue the wool with that color before it's actually woven. And the reason you do that, and this goes back to several hundred years, this phrase is, the reason that they actually dyed the wool and imbued the wool before they wove it is so the wool would stay that color and be permanent. So when someone says, I'm a dyed-in-the-wool Democrat, or I'm a dyed-in-the-wool anything, then you expect that to be, as the dictionary definition is, and when you're dealing with educated people that know how to use the English language, and they say, I'm a dyed-in-the-wool anything, then you go back historically and say, well, okay, this person says that this dye, this color, this belief, this opinion is permanent and not changing. So to do that, then you do your own historical analysis and you go back to the beginning. When someone says, from the beginning, I'm a dyed-in-the-wool Democrat, and you say, well, if this gentleman, when he gets out of school, is from the beginning a dyed-in-the-wool Democrat, is that consistent? So I think it's appropriate to go back to make sure that his words up till the very end match his actions. His words were, I'm a dyed-in-the-wool Democrat. His actions are those of a dyed-in-the-wool Democrat. So that gives you a pretty good indication of whether there's a genuine conversion. Can you somehow dilute or eradicate that dye that's in the wool? So that's why we went back to that.
Well, would you go so far as to say that if someone calls themselves a dyed-in-the-wool Democrat, that they're forever and ever and ever trapped and can never ever have an
epiphany?
Well, an epiphany, or the biblical character Paul was Saul, had the experience on the road to Damascus. Would you preclude someone like Tom Bernabei saying, you know what? In fact, I'm told that what really got him motivated to convert to being an independent so he could run was the Mayor Healy-Kim Perez debate that occurred pretty late in the election season, the primary, and he's, I'm paraphrasing, saying, gee, if this is what we've got as candidates, somebody has got to man up, step up, and I'm the guy. I can provide the leadership. And so could that event fit the Saul on the road to Damascus? He sees this has this enlightening moment. Do you buy that at all?
Well, I think you and I would have to be, as observers of the community and mankind, you and I would have to be persuaded that that event was of biblical proportions. And I sensed that a debate between those two candidates was not something of biblical proportions, and accordingly, you don't change your entire life's dye, if you will, your entire life's belief based upon a hearing a debate between two men that you've known for decades. So it's not like all of a sudden a unknown creature came in from out of space and you say, well, I have to act. This is some sort of intellectual invasion. So do I buy that? I guess the issue is really not whether I buy that. The issue is whether ultimately the Board of Elections and the court system buys it.
Now, in reading your brief, and of course you'll take exception to me if you think that I'm not doing a fair analysis, but my takeaway from your brief is that probably the motivating factor goes back to the time that Bernabei worked for Mayor Healy and as service director and chief of staff, and was fired about a year into that role. And this runs no deeper than animosity toward William J. Healy II. Is that a fair assessment of what you're proposing that might be the real motivation for Tom Bernabei trying to run as an independent?
Sure. I'm not here to judge what triggered it. I think most of...
But that was in your brief, right?
Sure,
right,
sure.
Right.
But just in terms of a perspective, I think that's a conclusion, that's a rational and reasonable conclusion to be drawn. But again, what concerns me is that those individual and personal triggers, whatever they might be, and it would be natural for someone that's accomplished and believes they have had a successful career to be terminated. That's not something that's a positive for anybody, and it would be natural for them to have those reactions. But again, the thing that I'm most concerned is that allowing this situation, or any situation like this, to cause people to say, let's forget about the rule of law, let's forget about the concept that no one is above the law, let's forget about good government, because good government is that there are certain standards in place, and citizens abide by those standards, otherwise it's anarchy. And we can't elevate a personality or politics above the rule of law or above good government. And I think this is the kind of thing that's happened, whether it's triggered by a personal vendetta or anger or vengeance. Again, that's something for somebody else other than myself to determine.
Now, the Board of Elections is kind of an interesting structure. The board members are appointed, two each, by the Democratic and Republican political parties. And in the case that there's a tie vote, as they make decisions for the Board of Elections, the members, the Secretary of State, who's either a Republican or Democrat, breaks the tie.
Yes.
And generally, they break the tie along perceived party interest lines. Not always, but many times. So are you, being the rule of law person you are, and people tell me, lawyers tell me that Lee Plakas has just really got Tom Bernabei in a legal bind on statutory law. And but boards of elections make decisions sometimes, at least it's my perception, on political grounds and affiliations. And for myself, I expect the two Republican members to find a reason to vote to certify candidate, independent candidate Bernabei. What's your response to that?
Well, the political issue is interesting. You would hope that even in this dynamic, that the elected members of the appointed members of the Board of Elections abide by their oath of office. And their oath of office is to uphold the laws of the state of Ohio. And you would hope that they understand that this is the kind of an issue, the rule of law issue, the good government issue, that no, you don't make exceptions to the rule of law and good government because of personalities or short-term political gain, because ultimately the decisions made will affect all of us. And ultimately, even though there might be a perceived Republican advantage for this issue, in 2 years or 4 years or 6 years, or very soon, perhaps next year in the national election, you can see that this sword has two edges. And I am hoping that we will see that people elevate their ethical and intellectual horizons and consider the global effect in terms of the political effect of what this kind of thing can determine. I hope that we won't fall prey to what Ronald Reagan, a great Republican president, said. He said that he's been told that that politics is the second oldest profession, and he went on to say he's now learning that there's not much difference between the oldest and the second oldest profession. So I'm hoping that all of the members of the Board of Elections will consider that this kind of issue and the rule of law and good government, and that you don't elevate personality over good government, and that no man is above the law. I'm hoping they'll consider that when they make their decision.
If they don't, and there is a tie, and the tie gets broken in favor of certification, are your clients prepared to go to the Ohio Supreme Court?
Yes, they are, and we are.
Okay. And now, taking it to that level, which is clearly it's going to be a rule of law question, although, as you and I both know, if the Secretary of State makes a decision and it holds water, just to use a layman's express, something that the Supreme Court can latch on to, chances are really pretty good, as happened in the George Meyer case, that the Supreme Court's going to endorse the decision of Secretary of State. Not always, but so that could be troublesome, couldn't it?
Well, if in fact the Secretary of State ignores the rule of law and the ramifications of ignoring the rule of law, and the Supreme Court does the same thing, then what you'll have when a society ignores the rule of law, then people adapt to that. And then what you would have is the ability to bus in dozens or hundreds of supporters for elections. They would have the ability to be housed in basements, and to say, well, I plan on making Canton my permanent residence. They would have the ability to check into or reserve rooms in hotels, and we will see elections where busloads of temporary voters would come in, but say, well, no, I plan to be a permanent resident in this community, even though I don't plan on living at the motel or in a basement. I plan on moving down the street. So if that's what the ultimate ruling is, then those are the consequences. And then society will adapt, and everyone will work to see how good they can become at that game. And that's why whoever makes these decisions has to understand that there's ramifications, and that sword will cut both ways.
You anticipated where I was heading next, and of course we haven't had a brief from Bernabei's side yet. In your brief, I don't recall you raising at all any constitutional issues. I anticipate that Bernabei's legal counsel will, and I anticipate that the focus will be on freedom of association and freedom of movement. So the response that you just articulated, would that summarize your thoughts if the Supreme Court were not just endorsing, using an abuse of discretion standard, what the Secretary of State did, but actually gets into the constitutional questions? Is the constitutional side of this case a difficult side? Your statutory side is very strong. Everybody that I've talked to in the legal community says Lee Plakas has that. He's got it cold. But his problem's going to be when, if it ever gets to the constitutional questions and the great prize that we have in America on people being able to associate with whomever, whenever, especially established political parties, and also to navigate, to move. Early in our history, that was a problem that the courts had to deal with. Would you want to pick up on that at all?
Sure. We're blessed with a number of constitutional rights and privileges. However, for society to function, there's always reasonable limitations. As an attorney, of course, and even if we weren't, we probably the constitutional right that everyone understands most is the freedom of speech. But that freedom of speech is reasonably limited because, as you and I think learned probably in our first torts class, that you're not allowed to exercise your freedom of speech and yell fire in a crowded movie theater, because that affects the ability of society to function in an orderly manner. And as long as there's reasonable and rational rules, then which I think there are in this case, and obviously there's already been some contests to try to declare these regulations invalid. They have failed. I believe that they will continue to fail, and I believe constitutionally there isn't a risk that this procedure will be overturned, because there has to be some organization, some format, and this is it, and it's clear, and I think I can't imagine a clearer or more distinct violation of both the spirit and the letter of these election laws.
Now, I've asked you a number of questions, and I never turn the camera off before I allow the person I'm interviewing to say, well, why didn't you ask me about such and such, or I want to go on about another matter. Is there anything that Lee Plakas wants to add to the discussion? Because one of the hallmarks of the Stark County Political Report is that my blogs are opinion. I work very hard to go out and get material to convince people it's a pretty good opinion, but I always allow for anyone to give their side of things. So is there anything additional you'd like to share with the readers and viewers of the Stark County Political Report?
You know, that's a very dangerous question for you to ask any attorney, much less a trial attorney, if there's anything more that they want to ask.
Right.
Because by nature, unless you turn off the camera, we will never stop. So having said that, I think that the rule that we try to use with jurors is, if anyone's watching this, they're going to start nodding off at some point, just like I try to avoid having jurors do that. But I think, just as I've said several times, this is an issue that's much broader and has greater consequences than whether an individual wants to be on the ballot for mayor. Because if, in fact, under these set of facts, this is permitted, then our elections, at least in this county, are going to be a Chinese fire drill. So I have nothing more. Edmund Mack, who's an extremely capable attorney and has done a great deal of work and evaluation in all of our legal matters that we do in this firm. Edmund, if you have anything to add.
Anything to add, Edmund?
No, I don't. Looking forward to July 6th.